Professor Milanovic, he joined University of Reading on the 1st of July 22. So not that long ago, and of course he was already professor in Nottingham. For us here at Reading, he's professor of international law and the director of the global law at Reading Research Institute. I recall your interview rather well, Marko, because I just checked in my diary, but we were interviewing you and a few others on the 25th of February 2022. You may recall that was the day, literally the day after Ukraine invaded. Sorry, Ukraine was invaded. Russia. It should have been the other way around.
Quick save. Yeah.
And I remember with Rosa and Mike in the panel, they were quite mean because literally it happened yesterday, and all the candidates were asked, okay, Russia invaded Ukraine. How are you going into a class today and have a conversation with students about the legal rights and wrongs of this action? And frankly, Marko, most of your competitors to this role were struggling a bit. And Marko came in and he said, oh, that's simple. The United Nations just printed a statement and I'm going to walk into class and work with my students through the statement. What is the legality behind this invasion? And I think we were all a bit stunned because we'd been sitting in that interview panel the whole day and didn't even know that the United Nations issued a statement. And I think it says a lot about you, Marko, the rapidness by which you respond, to be on top of the issues as they happen, and an ability, I think, to translate what's happening in the real world into the classroom. And our students need to have that kind of exposure. It's happening yesterday. Today we should be talking about it. And we were also impressed that it was one of the easier decisions we made to appoint you professor of public international law at the University of Reading. Now, Marko is more than just a quick thinker and somebody who impressed the panel. He's a prolific author in human rights law, public international law, the law of armed conflict. Background, PhD in Cambridge in international law, and then having served as a law clerk to Judge Thomas Morgenthau of the International Court of Justice. Marko has done a lot of work, particularly around armed conflict and around cyberspace, and is co-director of the Tallinn Manual 3.0, which is trying to deal with international law in cyberspace. And of course, Marko has also worked a lot with NATO, the Cooperative Cyber Defense Center of Excellence, and other NATO colleagues, some of them in the room. We'll come back to that towards the end of the session today. But being on top of what happens today in armed conflict, something of your way of working, and as long as it can translate into the classroom and into the research efforts, it's an absolute right place to be a professor of international public law at this university. Marko, I think they don't come to listen to me here tonight. They should be, but they come really to listen to me. So without further ado, I hand over to you, and interesting to hear what you have to say.
Thank you so much, Robert. Thank you. Thank you, Robert. Thank you all for coming. It's a great pleasure to give this inaugural lecture. I really want to start off by expressing how grateful I am to be working at the University of Reading and to have to be able to collaborate with so many excellent colleagues, particularly in the field of international law. And I'm really grateful to James Devaney and to Robert for the opportunity they gave me to become a professor of international law here. And I think really when it comes to international law and human rights, we here in Reading are really building an excellent team. Of course, I have to mention my great friend and colleague, Mike Schmidt, but so many others. We recently recruited Russell Buchan, who will start as professor of public international law in October, and so many other excellent colleagues, many of whom, of course, here in the room. And I only think we're going to go farther, and that this team will grow stronger and bigger. And I'm really grateful for the opportunity, Robert, that you have given me. So let me talk about the substance of my inaugural, which is the international prohibition of intervention. So this is a rule of customary international law.
Pick that up on state.
Fantastic.
Solid.
Fantastic. I lost my phone. They just found my phone. So
Hoover.
well done. So the prohibition of intervention is a rule of international law that is regarded as cardinal. It essentially prohibits states from coercively interfering in the internal or external affairs of other states. You can think about it as sort of a rule that preserves the decisional autonomy of states. Somehow the idea that every state, by virtue of being sovereign, has the right to freely make its own decisions. The reality, however, in international affairs is that states constantly exert various kinds of influence and pressure on one another. And the question, therefore, that the rule of intervention or the prohibition of intervention tries to sort out is what kinds of modes of influence of pressure are legitimate and which should be regarded as prohibited. When, for example, the US Secretary of State comes to this country and says, could you please not use Huawei equipment in your 5G infrastructure? But if you do, there might be some consequences for our relationship. Is that fair game? You know, is that how diplomacy should be done? Or are there some kinds of threats, for example, that states should not utter to each other? When Russia amasses its military a year ago on the borders of Ukraine and tells Ukraine, unless you do what we want, bad things will happen. Is this in and of itself a violation of international law? Or is this some kind of legitimate hard bargaining? Okay. So that is essentially the role that the international prohibition against intervention tries to perform in the international system. It does not, however, do so particularly well for reasons that I will explain. It is a rule that everybody talks about, but it is also a rule that almost everybody acknowledges is fundamentally unclear. The rule is one of long history. It already starts in the 19th century, but it really gets consolidated in a series of General Assembly resolutions in the second half of the 20th century, the most important one being the Friendly Relations Declaration. The key point for the case, the still classical sort of starting point for discussing this rule, is the International Court of Justice decision in the Nicaragua case, Nicaragua versus the United States, in which the court said that the prohibition of intervention forbids all states or groups of states from intervening directly or indirectly in the internal or external affairs of other states. A prohibited intervention must, according to the court, accordingly be one bearing on matters on which each state is permitted by the principle of state sovereignty to decide freely. One of these is the choice of a political, economic, and cultural system and the formulation of foreign policy. Intervention is wrongful when it uses methods of coercion in regard to such choices which must remain free ones, and it is coercion that forms the very essence of intervention. And the court then goes on to say force, the use of violence, is a paradigmatic example of coercion, but not the only one. Now, in that case, the court said that the United States violated the prohibition of intervention against Nicaragua by using force directly, by, for example, mining ports in Nicaraguan waters, but also by supporting a rebel group, the Contras, on the territory of Nicaragua. Some of this support was also an indirect use of force, the provision of weapons, the provision of training to the Contras. Some of it, however, fell below the force threshold. It did not engage Article 2, Paragraph 4 of the Charter, but was nonetheless coercion and thus intervention. And the court there regarded the provision of money and intelligence to the Contras as one such instance. However, economic sanctions that the United States used against Nicaragua, the court said, in very one laconic sentence, we do not feel violate the prohibition of intervention. Today, this rule is reaffirmed all the time. States talk about it all the time. They appear to agree on the elements of the rule, that there has to be an interference with the internal or external affairs of other states, what we can also call the reserved domain of states, and that this interference must be coercive. But they've never defined coercion. There's no authoritative document in international law that really tries to define coercion. And even in the Nicaragua case, the ICJ basically said nothing about what this concept means. It just gave us examples, but it did not explain what is meant by coercion. And really, the great controversy that has existed in the 20th century and so in the 21st century has been sort of as follows. We will all agree that force is coercive, but what kinds of activities below the threshold of force should also be regarded as coercive? Western states in particular have not wanted to accept that economic sanctions can be coercive because they use them all the time for what they think are valid reasons. The third world or developing states, which normally bear the brunt of such economic measures, do want these measures to be labeled as coercive. So that has been the biggest debate. Everybody will also agree that one particular thing is not coercion, and that's just talking. So if Mike Pompeo comes to this country and says, please don't use Huawei, simply talking is not coercion. If our foreign secretary goes to China and says, can you please respect the human rights of your people, that's not coercion. It's when coercions get coupled with potential consequences, when talking becomes coupled with potential consequences, that we may talk about coercion. So everything in between these two ends of the spectrum, force and talking, is in some sense a hard case. And so what I want to really do in this lecture is to provide a theory of how we could understand that space, that middle ground between force and talking. That's sort of my ambition here. Now, to do that, however, the theory that we would develop or accept of what coercion means must avoid being overly inclusive, inhibiting too much methods of state cooperation, of state influence, and it must also avoid becoming under-inclusive, being limited only to force, because we already have a rule prohibiting the use of force. So it must somehow draw a line in between. So this is my argument. My argument is that, contrary to attempts that have really sort of been the way coercion has been understood so far, where we have tried to come up with a single definition of the notion, we actually have two distinct conceptions of coercion, which coexist, which are complementary, but work very differently. The first is what I will call coercion as extortion. In coercion as extortion, the coercing state, the intervening state, performs three actions, sometimes two, sometimes three. It makes a demand of the victim state. It threatens the victim state with consequences if the demand is not met, and then it might implement the threatened consequences if its demands are unheeded. So demand, threat, harm. That's coercion as extortion. Russia threatens Ukraine. If you don't do what we say, if you don't denazify, demilitarize, de-whatever, yeah, there will be pain. Ukraine rejects that demand, Russia invades. That's coercion as extortion. Saudi Arabia and its partners demand of Qatar to comply with a list of 13 demands. Among them, for example, breaking off relations with Turkey and Iran, shutting down the Al Jazeera TV station, etc., etc., etc. And if you don't do that, there will be consequences. Qatar says no. What do the Saudis, etc., do? They expel Qatari nationals. They suspend flights. They suspend economic links. Saudi Arabia even threatens to physically sever the peninsula of Qatar from the Arabian Peninsula, right? So that's how coercion as extortion works. Demand, threat, harm. But there's a different type of coercion, which I'll call coercion as control, which does not involve this dynamic of demand, threat, harm. It just involves an action, okay? So the state, the intervening state, performs an action that in and of itself deprives the victim of the ability to control its internal or external affairs. Now, the best example here, the one that sort of provoked my thinking, if you will, about non-intervention, is cyber operations. Today, states, including our state, are all the time coming out with formal positions, expressions of their opinio juris on how international law applies to cyberspace. One thing they've done, for example, is to say that the old rule of non-intervention, including its coercion element, has to apply in cyberspace. The one example that all states that have brought out their position so far, some 20 or so of them, seem to agree counts as coercive intervention is election interference operations. Okay? So imagine now our prime minister is Rishi Sunak. He's the prime minister of this country because he was ultimately not opposed in the elections in the Tory party. Had he been opposed, the Tory party would have run an online election. And we have colleagues here from GCHQ that were apoplectic at the time about the security of the said election. So imagine if some other state hacked what I have no doubt is a magnificent cybersecurity operation of the Conservative Party, done at the level of sophistication no other state could match, and change the outcome of that election without us knowing. The only way this operation works is if we don't know about it. Yeah? All international lawyers, states that think about intervention, coercion in cyberspace will agree, well, this is coercion. But that works very differently from coercion as extortion. There is no demand. There is no threat. There is no harm that is being implemented. The demand is not met. The intervening state just acts. It acts to deprive us of our ability to control our political system. So I can explain how these two models work also by way of domestic examples. In domestic law, we have all sorts of crimes that, for example, punish extortion, racketeering, blackmail. They all follow this coercion as extortion model. There's a demand, there's a threat. That in of itself is criminal. It becomes even more criminal if you implement the harm. Yeah. So we have coercion, of course, in many other domestic contexts. But there are other ways in which we also think legally in domestic law of coercion. If, for example, I physically seized Robert and detained him, hi, Robert, without making demands or threats, I just seized him and say I'm a police officer, we would say that's coercion. If I searched his property without his permission, let's say that's coercion. Yeah? If I seized his money from his bank account, that's a coercive power of the state. You see what I mean? So coercion, even in domestic law, does not have to follow this demand, threat, harm pattern. It can also follow a different model, which is taking control over the person's affairs, or at least depriving them of the ability to control them themselves. States engage in coercion all the time. All of criminal law, for example, is coercive in the extortion sense. There's a demand by the state, don't commit these crimes. There's a threat by the state. If you do, you will be punished. And then if you do that, the state tries to prosecute you, right? So, but the state does not have only those types of coercive powers. If, for example, you're in prison, it is the very bars around you that are a form of coercion, not simply the demand, threat, harm. So I hope I'm getting across what I really mean by having these two different ways of thinking about coercion. And they really need to be thought of distinctly because they work in very different ways. Coercion as extortion works by exerting pressure. This is how Harriet put it in one of her papers, by exerting pressure on the will of the target state. you impose harms on the target state so that it changes its decision-making calculus. The pain outweighs whatever else the state wanted to do, and therefore it decides to do something different. But coercion as control works in a completely different way. The victim doesn't even have to be aware, as in the hacks of elections, or imagine hacks against COVID pandemic response, vaccine research, vaccine distribution, etc. Yeah? They really work in fundamentally different ways. So that's my basic argument. Now, did I just make this up? Well, to an extent. But I would posit actually that there are roots of these two distinct ways of thinking about coercion that go a long, long way. So even if you read very classical definitions of intervention in works such as Oppenheim, for example, you will see that they jumble these two different ways of thinking about coercion together. So for example, for Oppenheim, when they talk about prohibited intervention, they say the interference must be forcible or dictatorial. Dictatorial is coercion as extortion, demands, threats, yeah? Or otherwise coercive, in effect depriving the state intervened against of control over the matter in question. See, so even they, Jennings, Watts, Oppenheim, whoever wrote that language, they realized coercion cannot simply be reduced to the demand, threat, harm dynamic. Now, the second point I want to make is that a lot of the debates in international law about the definition of coercion have been plagued by what I will call the problem of justification. And that's as follows. We all intuitively think in domestic law and in international law that some forms of coercion are good, that they're justified. They can be good, used for good ends. If you're in the military, you're using coercion, but you hope you're doing it for a good cause. If you're a police officer, you're exercising coercive powers every day, but we would generally regard that as being justified. In international law, if the Security Council authorizes the use of force or sanctions, we would generally regard it as justified. But if you look at how the non-intervention rule in international law is framed, it is framed in absolute terms. So to quote, for example, the Friendly Relations Declaration, no state or group of states has the right to intervene directly or indirectly for any reason whatever in the internal or external affairs of other states. For any reason whatever. It seems like this is some kind of absolute rule. There is no balancing test in that rule that says, but an interference might be justified if it pursues some kind of legitimate aim, is necessary proportionate to that aim, of the kind we use in human rights law routinely, for example. No, the rule is stated in absolute terms. So what that means is that it leads structurally lawyers to argue not that coercion is justified, but that a particular measure such as economic pressure is not coercion at all. So we argue about the scope of the word of the prohibition because we do not have an internal mechanism of justifying good uses of coercion. There are some external ways of justifying coercion. So, for example, the circumstances precluding wrongfulness in international law, countermeasures, self-defense, etc. But actually, they have very limited application to the kinds of situations that we're normally talking about, and applying them is really far from straightforward. I mean, to give you a concrete example, when all the states in the world have implemented various economic measures against Russia in response to the invasion of Ukraine, one way of saying that's not unlawful is to say Russia is not being coerced. Yeah? When what we really mean by that is actually Russia is being coerced, but for a good reason, for a justified reason. Yeah? So the issue, the structural problem of how the non-intervention rule is framed means we are, as with absolute rules generally, pushed to argue about the scope of the rule rather than circumstances in which coercion might be justified. Good. So that's sort of my basic argument. Now, in the paper that I have written, which is 30,000 words, which some of you will have the pain of reading, I really sort of developed these two models of coercion in extensive detail. And there are many issues that arise out of them. One very important issue is attempt. So should states be responsible for violating the prohibition of intervention, even when they don't succeed in getting what they wanted? That's one problem. And I think the answer for both types of coercion is yes. So let me explain this very briefly. When you look at coercion as extortion, it can produce four basic scenarios. Okay. So first, the coercing state may make a demand and a threat, which the victim state rejects, and things end there. So the coercion failed to produce the desired result. There was just a threat. No harm was inflicted. The second scenario is the coercing state makes a threat and the victim state gives in. It complies with the demand. Imagine if Ukraine in February 2022 did what Russia asked it to do and Russia never invaded. Would we say in that situation that Ukraine was coerced? Yes. The threat of military force worked or could have worked. We should not penalize the victim state in such a situation by saying, well, you never got harm inflicted on you. The threat itself worked. Then you could have the imposition of harm that followed the threat. Russia has now invaded. But it's saying to Ukraine, do what we say, cease your useless resistance, to quote the foreign minister. Yeah, and we will stop. So that must be coercion, right? And then the fourth scenario is in which the intervening state implements the harms, but still doesn't get what it wants. The United States and Cuba, the Saudis and Qatar. The worst economic sanctions in the world are those that the United States has been having against Cuba for half a century. Cuba has resisted them to huge cost. But are we really going to say that simply by the fact of being successful in resistance, the victim state was not coerced? Yeah, I don't think that makes sense. The same applies to coercion as extortion, as control. The paradigmatic example of this is actually Nicaragua, funding a rebel group, supporting a rebel group. In Nicaragua, the court doesn't say, well, you have to make demands and threats. So the mere fact of supporting a rebel group on another state's territory, depriving that state of the control of its sovereign territory is enough. So imagine if Serbia sponsored a military coup in Croatia. We tried to bribe the Croatian generals to topple the government, but that failed. Now, the security services there arrested the generals. Are we going to say that's not intervention simply because the coup was unsuccessful? No, there has to still be intervention. In the same way, if a cyber operation was launched by, say, Russia against British elections, and GCHQ uncovered the operation, stopped it from causing harm, explained to the public, yes, there was this massive attack, against our elections, but we stopped it. Are we really going to say that's not intervention simply because Russia couldn't get what it wanted? In that same way, by the way, if you look at comparative domestic criminal law, virtually every system of criminal law that I'm aware of punishes not just successfully extorting somebody, but also attempting to do so. Yeah. So whether I manage to get money from you or not, in the end, it does not matter. Yeah. I hope you're with me on the attempt issue. The second really big problem is the threshold question, right? Remember, the issue is, how do you make a rule that's not over-inclusive, but it's also not under-inclusive? And there are, I would submit, several different ways of approaching that threshold question, both for coercion as extortion and coercion as control. The first is what I will call sort of positivist minimalism. Let's find those things that states universally or nearly universally agree on and label as coercion, and that's what coercion is and nothing more. Now that would be force or threat of force. That would be supporting rebels. It could be election interference operations because now states specifically agreed to that, and that's it. Unless you have general widespread agreement on a specific measure like economic pressure, it's not coercion. So that's the first approach. I don't like this approach because it undermines the idea that legal rules are general, that concepts like coercion have meaning, an abstract meaning you can unpack and apply in future cases. Everything will depend, for example, for some future issue, on whether you can get states to specifically agree on something, which they will rarely be able to do. I don't think this approach can really be justified, either formally, legally, or as a matter of policy. The second approach would be to say coercion consists of the imposition of those harms or those acts that violate the rights of the victim state. So for example, if I threaten Robert with something that would violate his rights, you could say that's coercive behavior in domestic law. You could say in international law, violating some pre-existing right of the other state could count as coercion. Maybe also rights of its nationals. Let me give you a good example here. When Iran detains dual British Iranian nationals in Iran, like Nazanin Radcliffe, and says to the United Kingdom, give us money, okay? Pay us what you owe us, and then problems will get fixed. That kind of situation is definitely a human rights violation of the individuals involved. Yeah? But couldn't we also say that by taking hostages, Iran is also coercing the United Kingdom? When Canada arrested the daughter of the founder of Huawei at a US extradition request, how did China respond? By arresting several Canadian nationals on its territory, who were immediately released after Miss Meng was released. So when you do that kind of act, when you violate the rights of the state or of its nationals, coupled with a threat, a demand, I think that's a reasonable line to draw to say that that's coercing the state, not just violating the rights of the individual involved. So for example, with economic sanctions, if the state threatened or implemented economic measures that violate some other rules of international law, for example, under trade law, investment law, you could say, well, that's coercion. But if they just do retortion, measures that are not in and of themselves unlawful, that's not coercion. So that's the second possible approach. The third approach is to not focus on legality of the underlying harm, but on its severity. So if you look at what America does to Cuba, the issue with the economic sanctions against Cuba is not that they are violating some rule of international trade law. The problem with them is in the harms caused to the normal Cuban person. The fact that they live in the first half of the 20th century by virtue of the American sanctions. That's the problem. That's also how they work. It is the intensity of the pain inflicted on the victim that causes the victim to change its behaviors. So that's the third option, to look at the scale effects of the harm. Something we, by the way, already do in other contexts. We do that, for example, in defining the notion of an armed attack or the use of force, etc. We could apply the same approach below the force threshold to what is coercion. Now, the problem with this approach, or the feature of this approach, is that it'll capture some acts that are legal. So I could threaten you with legal economic harm, for example, and that would be coercion. I don't have a problem with that, but some of you guys might. Okay? We frequently prohibit things coupled, for example, with threats that are otherwise lawful. The crime of blackmail in most jurisdictions involves a combination of two legal acts. If I ask James for a raise, hey, James, okay, that's legal. If I learn some compromising item of information about James, his internet browsing activities, and threaten to disclose them to Robert, that's also legal. Two legal acts. But if I say to James, unless you give me a raise, I'm going to talk to Robert, that's blackmail. And two legal acts together become a crime. People call that the paradox of blackmail, but there's nothing paradoxical about it. Yeah. So, for example, to give another example, it's legal to get drunk. Good luck at dinner. Okay? It's also legal to drive a car, but to drive a car while drunk is a crime. Yeah. So threatening lawful but severe harms coupled with a demand can be regarded as coercion, can become unlawful. There is no principled reason why it couldn't be. The issue is, do we want that? Because it really expands the boundaries of the non-intervention rule, particularly in a way that Western states so far have not wanted. Now, the same sort of three approaches can be applied to coercion as control. When it comes to coercion as control, do we look at whether the underlying act is itself somehow violating the rights of the victim state? Do we look at the severity of the harm? So if you think about election interference, if Russia just hacked the local election in whatever, Reading, is that violating the prohibition of intervention? But if they hack the national election, if they hack voting machines, if they change the outcome, yeah, so the scale changes suddenly, we can more easily agree that this behavior is coercive. So that's sort of my spiel, if you will, on the threshold. There are various other questions that we can talk about if you have questions. For example, the issue of intention and knowledge, whether coercion requires some kind of subjective element, which has been debated in the literature, to my mind, largely practically unnecessarily, if I can put it that way. So, for example, in coercion as extortion, intent is manifest. Whether you legally require it or not doesn't matter, because everybody can see it. Everybody can see that Saudi Arabia intended to force Qatar to comply with its demands, that Russia intended Ukraine to comply with its demands, etc. It's not rocket science. The victim state will always know in coercion as extortion that it's being extorted. How could you not know? Things become a bit more complicated when it comes to coercion as control. But we already explained, for example, how in cyber operations, it's when you don't know about them that they're most effective. Yeah. And I see no reason of principle why we would require the victim to be aware of the harm caused to it. Yeah. But there is an interesting question of whether we should require intention in that type of scenario. So imagine, for example, Serbia intends to hack the elections in Croatia and launches malware into Croatia. But as so often happens, the malware escapes its control and also affects the elections here in the UK. Yeah? Serbia intended to harm Croatia. It did not intend to harm the UK or to affect the elections in the UK, but nonetheless, its conduct had that type of effect. So that's the one scenario where I think this issue of intention really matters. If you ask me, I would very much prefer there to be an intention requirement, because it serves to capture what is really distinctive about the notion of coercion. So I will end here. the last bit that I would really want to sort of mention is this problem of justification, to come back to it. Again, a huge reason why we have not been able to settle on a definition of coercion is because we regard some coercive measures to be justified. My own view would be this: it is better to have a coherent conception of coercion and then to say, well, listen, coercing states is actually lawful if what you're doing is trying to get them to comply with their international legal obligations. If you impose economic sanctions against Russia in order to compel it to desist from its invasion of Ukraine, you are not interfering with the internal or external affairs of Russia that Russia has a free choice on within the bounds of international law. You are coercing them. You're just doing it for a legally valid reason. And so my suggestion in that sense that I developed fully in the paper is that it's actually the reserved domain element of prohibited intervention that has greater promise to address this problem of justification than fiddling with the notion of coercion. So I will end here, and I'm very, very, very happy to take your questions. Thank you so much.